my copy of the contract not having a signature from the dealership doesn't matter?
It really doesn't.
And you being the trustee in this case doesn't matter?
Well, I'm not a trustee, sir. I'm a judge.
You are, because I appointed you one.
You're the trustee. Just like the Secretary of State is trustee of it.
About this particular case, you've alleged that I'm your trustee. I'm asking what information or proof that you have that that is true.
So you're just denying it?
I don't know of any information that makes it true.
Okay. If it was
What information do you have?
Are you asking me that question? I have no idea what you're talking about.
You don't know
I
what I'm
suspect the answer is no, but we're really not going to go down that road.
I'm not sure. I just believe that you are my trustee, and if
Looks like Ms. Walsh, are you going to be arguing this?
That's correct. Good afternoon, Your Honor.
And I think I see a Jeffrey Lawrence.
Jeffrey-Lawrence, Coen beneficiary.
This case involves a defaulted vehicle loan for a recreational travel trailer. Defendants executed and entered into a retail installment contract with the dealer. The last payment made on the loan account was on or about December 28th of 2021. The balance owing to plaintiff is the principal sum of $35,928.21 plus late fees in the amount of $53.88 plus accrued interest in the amount of $1,325.37, while they have submitted many pages of inadmissible hearsay, including excerpts from several books and alleged excerpts of statutes and constitutional provisions and postal tracking information and other materials, documents that appear to have been drafted by defendants themselves that have names like conditional acceptance or bill of exchange or a declaration of the Naturalization Act of July 1779 for Jeffrey L. Cowgill status correction to the land and soil jurisdiction, not Sea Admiralty. They elaborate on the allegations that the credit union rejected payment that defendants allegedly made by submitting a form 1099A, like an IRS form, and a promissory note. But those forms of alleged payment are not legal tender, and the credit union was not obligated to accept them as forms of payment. Defendants also argue that they sent a bond coupon in the form of a promissory note to the credit union as an attempted tender of payment under the contract. However, defendants have not submitted any admissible evidence to support that proposition, and even if they had, that is not a valid form of payment. So the plaintiff asks that the court enter the revised proposed order granting summary judgment to plaintiff.
Mr. Cowgill, I did, just so you're aware, I did read through your response and attachments. So if you have, I'd like to hear what argument you have in response to counsel.
Without prejudice, I, Jeffrey-Lawrence Cowgill, with Teresa-Ann Cowgill, the beneficiaries, making special appearance sui juris propria persona under fraud, menace, and duress before fiduciary Basher. This is a CESTUI trust action, which you are now a real party in interest to. I'm the living, breathing man on the land and soil. The dead entity, all caps, Jeffrey Lawrence Cowgill, was expatriated, and I, the living man, have an unrebutted UCC-1 lien and security agreement with the all caps entity, and Gary Basher serves as the entity trustee in a fiduciary capacity. Virginia law further provides to authorize such filing, the debtor must do so in an authenticated record by authenticating or becoming bound as a debtor by a security agreement, or 3, by acquiring collateral. I have supplied that to you, that there's a UCC-1 claim. The plaintiff's agents are outlandish, stating Federal Reserve published documents are hearsay. Statutes and constitutions are admissible under 56B, as it states. The defendant may move with or without supporting affidavits for a summary judgment in such party's favor as to all or any part thereof. Since the plaintiffs have violated RCWs, UCCs, and U.S. codes, among other laws, these laws are fact and admissible per CR 56B. The plaintiff says the conditional acceptance is a nonsensical document, yet it is in Black's Law Dictionary under conditional acceptance. The definition is an engagement to pay the draft or accept the offer on the happening of a condition. A conditional acceptance is in effect a statement that the offeree is willing to enter into a bargain differing from some respects from the proposed or the original offer. The conditional acceptance is therefore in and of itself a counteroffer. We conditionally accepted the offer of the plaintiff, but the plaintiff ignored us, knowing that the conditional acceptance stated acquiescence would void the original contract. The postal tracking combined with the Esquire Scroggins letter is fact and evidence to the plaintiff receiving the bills of exchange that they did not return. The plaintiff's agent, Esquire Bertolino, admitted they received them as well. What qualifications does any of the plaintiff's agents have to declare what is and is not a bill of exchange? Since the plaintiff's agents, the Esquires, lied about the redacting and have submitted evident affidavits that they are not qualified to submit, how can their words be trusted? They are not bankers, nor is Mr. Howard. What is his qualifications to make such declarations? He looks at a piece of paper, the plaintiff's agents hand him, and he takes it as gold. I have people at work that know federal and state policies and procedures, but they're clueless as to what those policies and procedures are for. How can Mr. Howard be trusted acting as an entity's agent? No offense, lawyers lie all the time. Fact, Agent Howard produced a terrible photocopy that has a signature on it for the dealership that is not on our copy. Who signed the contract? Can the plaintiff's agents prove that an authorized representative for the dealership that is delegated by the plaintiff signed that contract? The plaintiff wants to rely solely on the contract, so let's talk about the contract. Who signed it for the dealership? Why hasn't the plaintiff gotten an affidavit from the dealership? Because they don't know who signed it. Washington rule does state that the photocopy can be used in the original's place unless there's genuine question of the original. And that alone poses a major question. Where is the original? Is a signature on the original more legible? Is there any other evidential factors on the original that can give us the answers to that truth? On the UCC, we did tender for payment bills of exchange, who the plaintiff's agents are not qualified to decide with their opinion what is and is not a bill of exchange. And as for where the bills of exchange are, ask the plaintiff. What did they do with them? They did not send them back. What did they do with them if not monetize them for gain? Esquire Bertolino states that the instructions on the 1099-A state tangible property is not included, yet the exact wording is no reporting is required, meaning you don't have to, but you can. It does not say no tangible property, so Esquire Bertolino lied. The plaintiff has violated many UCCs, U.S. codes, not just 12 U.S.C. 5511B2, C codes and definitions on everything that the plaintiff has violated, and I have proven the facts. Why didn't the plaintiff return the documents they say are not bills of exchange with an explanation or dishonor? Why wait and have Esquire type up some bunk letter and still not return those bills of exchange? When you're doing something and you find out that there's fraud or some shenanigans going on, you stop. That would explain why we made payments until we found out that there was fraud. Payments in fiat currency were being made until we discovered the truth and the plaintiff's agents violated laws and codes. All they had to do is return the bills of exchange with dishonor and or validate the debt or answer the conditional acceptance. Instead, they ignored us. That's why we're here. The Federal Reserve publications, like Hearing the Truth from the Horse's Mouth, state exactly how banks operate. How is that not fact? The Federal Reserve dictates what the banks can and cannot do. I'd say their publications are not only admissible, but damning to the plaintiff's complaint. As the plaintiff, they have to prove their complaint, and not only are there holes in their contract theory because of the signature, but it begs the question, why are they dismissing the UCC, which all banks and courts are bound to? And why didn't they rebut the UCC one? And as for the Leach Act, I submitted the copy to the court from the plaintiffs behind a sealed financial record. There's no explanation for these agents or their office to be passing around sensitive information that the agents do not need. So they did violate the act. What is their confidential material protocol? Who has seen the documents and where is it stored? How was it sent to the plaintiff's agents? By mail, fax, email? So how can you tell me it was secured when they didn't take the precaution when they send it to me in regular mail, not certified? The plaintiff never asked if they could share our personal information of that magnitude. This alone sets forth facts to either dismiss or send this complaint to trial, so the plaintiff's agents can be questioned. Put the qualified bankers on stand so we can find the truth. The plaintiff's esquires are not qualified to speak on the plaintiff's behalf. And Mr. Howard is not a banker, so neither is he. I sent, and if you use it without prejudice, like I have, a 1099-A can be anything I want. I can write a bill of exchange on a blank piece of paper. It's what they do with it. They didn't send it back with dishonor. They didn't send it back at all. All they said is, well, now we're going to limit how you can and cannot pay. And so they violated the UCC. And with that, I'm done.
Any brief response?
Thank you, Your Honor. The retail installment contract expressly provides that that the borrower must, or the borrower agrees to pay the amount financed and the finance charge in U.S. funds according to the payment schedule below, as explained on section 1 on the back. That's at Exhibit 1, page 2. It's undisputed that the defendants did not do so, that they defaulted under the terms of the contract. They don't dispute that they received the trailer. They don't dispute that they received this loan. They don't dispute that they made payments under this contract. They knew how to make payments under this contract. And they don't deny that they stopped making those monthly payments. There is no genuine issue of material fact that they entered into the contract, that they defaulted under the terms of the loan, and that they owe the amounts set forth in the Howard Declaration. It's, not appropriate for defendants to malign attorneys generally, or my colleague, Ms. Bertolino, in this court, with no evidence, no admissible evidence that would support any of the allegations that defendants have stated here today. There is no demonstration, no allegations, no demonstration of fraud by the credit union or by anyone. There is no, defendants just simply have not created a genuine issue of material fact regarding the credit union's claim for breach of contract or its entitlement to replevin in this case. And that is.
Once a dispute reaches court, the strongest argument is usually the one supported by admissible evidence, not the one supported by the most paperwork. When someone becomes committed to a legal theory that the court does not recognize, every new filing can reinforce that commitment instead of fixing the original problem. That makes changing course feel harder, even as the legal position becomes weaker.
Those are the plain facts.
So I got one question I have, which is not necessarily germane to my decision. Does your client still have the bills of exchange that were submitted?
That I don't have an answer for you today.
Your Honor, I've asked for them back and they just blatantly ignore me.
All right. Well, when I look through this, I mean, there's a lot of interesting theories that are kind of flowing all through this. What it boils down to, from what I gather, and it seems to be undisputed, is you folks went in, you bought a trailer on time, agreeing to make payments of some amount, pay it off. At some point in time, there was an issue arose where you decided to do something different. and then no more payments were made. There were some submissions of bills of exchange as an attempt to make a payment, as well as a 1099 as an attempt to make a payment. I guess my answer to that is those probably would not be something you could walk into Safeway and buy a banana with, because it wouldn't be considered regular money for purposes of buying things in a retail situation. They may work in a UCC type thing or something that this is simply a consumer contract to buy a trailer and make payments on it. And when you're all done, you get the title. The credit union, it appears without any objection, has security interest, which is indicated in the title as the legal owner. And I've not heard, I mean, there may be some other claims, but that you may have against them. I'm not making an assessment of that, because even if you did, it would not upset the contract to buy the trailer. So, I mean, you buy the trailer, you got to make the payments, you make the payments, they get the trailer back. So I am going to grant the motion for summary judgment. In doing so, I want to just give you some guidance, sir. What will ultimately happen is they get the trailer back and then they sell the trailer to somebody else. They apply the funds they get from that against the bill that's still owing. So the more money they get out of that trailer, the less money you end up having a judgment for. Does that make sense? So it's in your best interest not to do anything to the trailer. It's probably in your best interest to hook it up and drive it down to the credit union, because that would save some costs.
Oh yeah, I don't have a truck to do that, so they can come get it.
Oh, okay. I'm just trying to point out it's in
And
your,
so my copy of the contract not having a signature from the dealership doesn't matter.
it really doesn't.
And you being the trustee in this case doesn't matter.
Well, I'm not a trustee, sir. I'm a judge.
You are, because I appointed you one
I
as
did-
the beneficiary, because I'm not to do that.
Okay, I'm not able to accept that as a Superior Court judge.
So what about them just putting out our social security numbers without our, like, say so? Like, they could have completely ruined our credit. Someone could have those numbers and be doing damage to us right now.
Well, if those were passed to the attorneys as part of the collection, then that would be something that would be allowed. If that was sent out beyond that, obviously that's a separate issue. And if in fact that were a claim that were proven, there may be something there. But again, that doesn't affect the contract. Those are all other claims that you may have. I'm not saying you do or you don't, because I don't know enough about those, even based on all the information that you filed. And I read through all the stuff you filed, because it's what I do when I do my job. So
So can we have those forms of payment back?
I
Can
would,
you order them to return those to us?
well, I think it's appropriate if there's some value in those should be returned to
There's a lot of value in them if they still have them. And if they don't have them, then
Then what happens if they don't return them?
Turning to Ronald Hargrove.
Jonathan Baber on behalf of Mr. Hargrove.
All right. Is Mr. Hargrove here?
I do see a Ronald Hargrove name. There we go.
Okay. I think I just heard him. He's coming on. All right.
Thank
Okay,
you, Your
Mr.
Honor.
Hargrove. Go ahead, Mr. B.
Yeah, today is the date and time set for a couple of things. It's a status conference, Judge, but it's also a hearing date for my motion to withdraw. I'm really just going to rest on what I put in my written motion for this court. I really can't disclose too much more in regard to what the conflict is between me and my client without risking attorney-client privilege, and I don't want to waive that on behalf of Mr. Hargrove. But I do believe there's been a breakdown in the communication between me and my client. We just aren't seeing eye to eye on certain aspects, and I want to respect his wishes on how he wants to have his case represented. So therefore, I'm asking this court to consider withdrawing me from the case.
All right. Mr. Hargrove, well, first of all, Mr. Baber, you are appointed to represent him. Is that correct?
I
Yeah,
am.
I do see that in your motion. Okay, give me just a second to.
And I want to stress to the court too, that Mr. Hargrove has been very respectful. It's just a situation where we just do not see eye to eye on certain things.
All right. So, Mr. Hargrove, you understand what, without getting into details, because I've read the affidavit of Mr. Baber, but do you understand what he is saying?
Yes, sir.
All right. Now, if I allow him to withdraw, which is what I'm leaning towards right now, I'm not sure whether there will be another attorney appointed for you or not. I don't know.
No, I was just confused about a bunch of things.
Right. But, you know, when there's a significant disagreement as to how to proceed, an attorney cannot go ahead and present something to the court that the attorney believes is not justified by law or fact, even if his client thinks it is. So he can't do that if he believes, I mean, that's against the rules that we have to practice under.
Okay. Well, let me ask you a question.
But you can ask it, I'll answer it if I can.
Are you the trustee for the CESTUI account, Ronald Jean Hargrove II, or any account thereof?
Are you asking me that question? I have no idea what you're talking about.
You don't know
I
what I'm talking?
suspect the answer is no, but we're really not going to go down that road. Right now, the only question is whether or not Mr. Baber should be your attorney or not. He's filed a motion to withdraw, saying that he can't, basically you have a disagreement on how to proceed. That's too significant for him to proceed.
Okay.
All right, so I'm going to allow him, Mr. Baber, was there an order that accompanied your motion?
No, Judge, I will prepare one and present it to the court by tomorrow.
All right, that's fine. I'll go ahead and sign that. Mr. Hargrove,
Yes, sir.
you wish to have another court-appointed attorney?
No,
Or do you want to represent yourself or hire your own attorney?
well, I guess I'm not going to get anywhere. No, my questions aren't being answered. So I don't know what to do.
Well, I need an answer. If you want to request another attorney, I can have you interviewed again by MIDC. They may or may not appoint an attorney for you or allow one. What do you want to do?
Well, I guess I'll go forward with an attorney, and
Okay, so here's
I have a witness and some other things.
Okay.
I guess I need an attorney.
Well, I mean, it's up to you. I'm not necessarily going to appoint one for you. Ms. Parker, is Mr. Brown there?
Yes.
He has, he just popped on. Mr. Brown, this is a bit of a new one on me. I don't know if you heard it all. Mr. Baber was appointed to represent Mr. Hargrove. He withdrew because they had some disagreement on what should be presented to the court. And I've allowed the withdrawal. Mr. Hargrove still wants a court-appointed attorney. Does that have to go to Mr. Slough, or is he simply re-interviewed by you?
I don't necessarily know if he even needs to be re-interviewed unless things have significantly changed, as he did have a court-appointed attorney. So unless things have significantly changed, I don't think a withdrawal would require a re-interview. I think he would just have to be appointed another attorney.
All right, so we'll notify Mr. Gilo's office of that. Mr. Hargrove, that attorney would be appointed for you. You'll be given the name and number of that attorney. You should give them a call. Pam, if you call, or that attorney, would you also let them know they may want to call Mr. Baker?
I'll try to remember.
Yeah, okay, I get it completely. But Mr. Hargrove, I suspect that if this attorney has the same situation that Mr. Baber does, you may end up representing yourself or having to hire your own attorney.
Well,
Okay.
I wish you would just please answer my question.
Well, that's nothing that I can answer in a situation like this. The only you need an attorney, you've requested an attorney. If you're the next time you come to court, I won't be here because there'll be another judge. As my term ends at the end of this month, in about 10 days or so, 12 days. So you can, any argument would be presented to them, but it has to be done according to the court rules that we're all bound by.
But you don't have to answer my question.
All right, Ronald Hargrove, file 24-43189 ST. I see you, Mr. Hargrove, on Zoom. You represented by counsel, Mr. Hargrove?
I represent Mr. Hargrove, Judge.
All right, thank you.
What we're going to ask the court to do is accept plea to count 1 with the second offense dismissed.
Mr. Fortier, is that an accurate statement of the agreement?
I don't know yet, Your Honor. I can't find the case for some reason.
All right, I'll give you a second.
Mr. Gilo, did Miss Brooker email you that offer?
Yes, on the 9th.
Okay. Then yeah, Judge, that would be what we're gonna do then.
All right. Mr. Hargrove, you've heard the attorneys talk that there is an agreement being offered to you that if you plead guilty to the first offense of operating with your license suspended, the notice for second offense, which enhances the penalty, would be dismissed. Is that what you want to do? You're on mute now, Mr. Hargrove. You're going to have to take your, there you go. Is that what you want to do today? I'm sorry.
I just had a few questions.
Well, you're going to need to talk to your attorney about those questions. Do you need some time to do that?
He can't answer them for me.
All right. Well, then what are your questions? Let me see if I can answer them for you.
Okay, well, I don't understand how you can be the trustee of my CESTUI KV account, Ronald Gene Hargrove II, and not have my best interest.
I'm sorry, what I don't understand what your question is.
How can you be the trustee of the CESTUI KV account, Ronald Gene Hargrove II, and not have my best interest?
What is that account that you're referring to?
Oh, God. The CESTUI KV
Yes, it
account
is, but
that everybody
Go ahead.
most people have, and you're the trustee. Just like the Secretary of State is trustee of it. You are my trustee, aren't you?
not that I'm aware of.
Uh-oh.
Why would I be your trustee? Mr. Gila, do you have some additional information that I'm not picking up on?
No, Judge.
It's just something that I believe in, and I've seen evidence of, and
What leads you, Mr. Hargrove, what leads you to believe that I'm your trustee?
because of a former case I've seen.
A former case, what former case are you referring to?
In Roscommon, a friend of mine asked the judge that, and he couldn't answer him. So
That's probably because it's not factually true. What information do you have that leads you to believe that I'm a trustee for you?
In that case, the judge quit 6 months into his new term because he was dishonored, and the sheriff. So,
Mr. Hargrove, the question was not about a Roscommon County case. It was about this particular case. You've alleged that I'm your trustee. I'm asking what information or proof that you have that is true.
so you're just denying it?
I don't know of any information that it makes it true.
Okay. If it was
What information do you have?
If it was a misdemeanor,
go ahead.
If it was a misdemeanor, would it be true?
No. Misdemeanors and trusts have nothing to do with each other.
Okay,
There
well,
has to be some court order for me to be a trustee for you. For anybody to be a trustee, there has to be a court order. Do you have such a court order?
no. I just believe that you are my trustee of the CESTUI account, Ronald Gene Argo II, and that's.
Could you speak a little more clearly and tell me what that account is?
I'm not sure. I just believe that you are my trustee, and if you deny it, then you deny it. Okay, we'll move on from there. I guess, and another thing is I paid $1,000 for a reinstatement fee, but you guys keep saying I don't have a license. And where did my $1,000 go? I don't understand this.
Who did you pay $1,000 to, Mr. Hargrove?
The Secretary of State or the
Then you
state
need
of
to ask the Secretary of State.
Well, I believe I have my license, and they just keep, there's a screw up somewhere.
Then you need to contact the Secretary of State, but I'm not connected to the Secretary of State. I'm the court system. I work in the court system. I don't work for the Secretary of State, so I can't tell them what to do. If you believe that you paid the money and you should have a license, you need to contact the Secretary of State.
Okay. Well, knowing that I think I had a license at the time, doesn't that change things?
It would change things only if it were true, and I don't know that it's true. Just because you believe it doesn't make it true.
Yeah.
All right, Mr. Hargrove, your attorney has told me, and the prosecutor has agreed, that there is an offer on the table for you to plead guilty to operating with license suspended in exchange for dismissal of the second offense notice, which makes this a much more serious charge.
Okay.
Do you want to accept that today, or do you want to have some additional time to speak with your attorney?
No, they don't have nothing to say to me. Their best interest is of the court. So I'll take that, and I would hope to get the same fine everybody else did today. Thank you very much.
Well, I can't guarantee that because you're in a different circumstance than everybody else.
Well, I'm pleading guilty to the same offense they just pled guilty to.
But your background is not the same as theirs.
You know what? I'll plead insanity.
We recall Mr. Hargrove's case, People versus Ronald Hargrove, file 24-43189-ST. We are here for a jury status conference. If I could have the appearance of counsel, please.
Amanda Brooker appearing on behalf of People.
Kerry Gilo on behalf of Mr. Hargrove.
Mr. Gilo, have you had, since the last court hearing, have you had sufficient time to speak with your client?
I have, Your Honor. We would ask you to accept a plea agreement of no contest to count 1 for lack of memory, and the second offense notice would be dismissed.
That is a correct statement, Your Honor.
Thank you. Mr. Hargrove, do you understand what the attorneys have just said to me?
Yes, Your Honor.
All right, you are currently charged with driving with a license suspended as a second offender. The second offense notice increases the penalty up to 1 year and or $1,000 fine. The first offense notice, which is what you're going to be pleading to, has a maximum of 93 days and or a $500 fine. Do you understand the difference between those two things?
Yes, sir.
All right. I'm going to inform you of certain rights that you have right now that you would be giving up if you wish to enter a plea. So I want you to listen carefully. You have the right to have a trial by a judge or by a jury. You have the right to see, hear, and question any witnesses at that trial. You have the right to call witnesses to speak for you at trial and to get an order called a subpoena to require those witnesses to appear and testify on your behalf. You have the right to be a witness for yourself or to remain silent as you choose. And if you choose to remain silent, that silence cannot be used against you because you have an absolute right against self-incrimination. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt and to have that burden of proof be on the prosecutor at all times. If you enter a plea today, all of those trial rights would be waived or would be given up. Do you understand that?
Yep.
You retain your right to have your attorney assist you at any trial or at any plea that you have, like Mr. Gilo is doing today. Has anybody promised you anything or threatened you in any way to get you to plead guilty?
No contest, Judge.
I'm sorry, no contest. Thank you, Mr. Gilo. Has anybody promised you anything or threatened you in any way to get you to plead no contest, Mr. Hargrove?
No, no, Judge.
Are you doing so of your own free choice and free will?
Yes,
Raise your right hand so I can swear you in, sir. You swear the testimony you're about to give would be the truth, the whole truth, and nothing but the truth, so help you God.
yes,
All right. Mr. Hargrove, are you pleading guilty or pleading no contest because you want me to accept that just like I would a guilty plea?
yes,
All right. You understand that a no contest plea has the same effect as a guilty plea? You simply
Yes.
don't have to tell me what it is that you did, but the consequences will be the same. You understand all of that?
yes. I wanted to simply, as a simple, to give you a simple explanation of what happened, but
You're going to have an opportunity to do that in just a minute. But I simply want you to make sure that you understand what your rights are. All right?
appreciate that.
Mr. Gilo, what is it that you want me to use as a factual basis to establish the charge?
You should have an affidavit of probability there.
I can send one down if the judge does not. This may have been a ticket arraignment, so I'm not sure if the court would have that or not.
I do have an affidavit of probable cause. Let me get it out. All right, Mr. Hargrove, there is in some cases prepared what is called an affidavit of probable cause. It is a short summary prepared by the prosecutor's office of what they believe the facts of the case are. Do I have your permission to review that as the basis for your no contest plea?
Please.
All right, let me do that. Cause signed in October of 2024. It indicates that in the city of Gaylord and Otsego County on or about October the 11th of 2024, there was a traffic crash. The police investigated, were called to the scene, were informed by the driver of the vehicle that was hit, rear-ended, which was on West Main Street near the intersection of Dickerson Road, that the other driver had made an admission of not having a license. Police interviewed the other driver. He was identified by his identification card as Ronald Hargrove II, and he admitted to the police that he did not have a driver's license and was suspended. I find that that is a proper factual basis for the driver's license suspended, and will accept the no contest plea, finding it was entered knowingly, intelligently, and voluntarily. Mr. Gilo, is it your intention to proceed directly to sentencing?
Yes, Judge.
Ms. Bruker, any objection?
No, Your Honor.
Allocution, Mr. Gilo.
Judge, I'd ask the court to just assess the minimum fines and costs relative to this case. Mr. Hargrove has some medical issues that he has to deal with. And it's not a, I don't believe that there, excuse me, but I don't believe that there's any restitution that has to be ordered on this particular case either. So with that said, I'd ask the court maybe a short term of probation, if any.
Ms. Bruker, your comments?
I just note he's suspended for 625 offenses. He's been suspended for quite a while. That's all I really wanted to make the court aware of.
All right, Mr. Hargrove, you now have an opportunity to tell me anything that you want about this particular case and about your circumstances. You do not have to make a statement, but you're certainly able to do so if you want to. So go ahead, sir.
Thank you. I'll keep it short. I had hired a driver to go with me, and he had some mental problems, and he jumped out of the car while in motion and ran down the freeway, told me he was going to kill himself. So I tried to do what I had to do to try to retrieve him, and and I got and in this process, I broke the law, and I really didn't even have time to think, and I apologize, and I just I'm caught in a vicious circle, you know, of going to the doctors and having to do things, you know, getting stuck driving sometimes, and I just hate it. I feel like a prisoner in my own home. I feel like I don't have the right to praise my God, go to church. I just feel like a prisoner in my own home. It's just a vicious circle I can't get out of, and I'm very upset.
I can tell that you are upset, sir, and I'm sorry that you feel that way, and I wish there was something I could do to help you with that. But going out and driving isn't going to help that situation at all when you have a suspended license. And unfortunately for you, in this case, you got yourself into an accident, and the police had to be called. So all I can say is you have to do what you have to do. And in this case, what you have to do is not drive when you don't have a driver's license. And even though you may feel overwhelmed at times, there are good folks in town who will assist you with where you need to go and what you need to get. So plug yourself into one of the churches or one of the charitable organizations. There's lots of people in this town that want to help people. So opportunity to do that for you, sir.
I'm in the back of the woods over here, and I don't have that opportunity like you do in Gaylord, as you say. And I get very nervous with most people that drive, so it's very hard to find someone to travel with.
Well, it's a hard road to hoe if you're trying to do everything on your own. We are meant for relationships and helping each other out. So let the people around you do that. All right. As to today, all right. Anything else you want to say, sir?
No, I'm just overwhelmed.
Well, I am going to simply impose the minimum fines and costs and the minimum normal sentence that we do. I'm not going to add to your burden any more than I absolutely have to. So I'm going to say there's a crime victim fee of $75. There's a justice assessment of $50. Court costs of $50. Local charge of $15. Fine of $25. Can you pay that in full today?
If I was in the area, I can do it tomorrow.
It's $215.
All right.
How long do you think it would take you to pay that?
I can pay it tomorrow. If I live in St. Helen.
All right. I'll give you 7 days to do that.
Thank you.
Ms. Brucker, is there any request from the prosecution that I place him on probation for any term? I know you said that would be okay with you, but is there anything specific that you want to have happen on probation?
No, Your Honor.
All right, I'm simply going to leave him with fines and costs. Sir, if you pay that off within 7 days, you won't have to be on probation. I won't have to add any fees to that. So you're going to get out of this with $215 in fines and costs with 7 days to pay, and you won't be on probation. However, if you don't do that, then I do have to put you on probation to extend the time for you to pay that off. You understand what I'm saying to you?
I think you're more than fair.
All right.
I appreciate you.
That will be the order of the court then, sir. Good luck to you.
Thank you.
These two hearings show the difference between believing a legal theory and meeting the legal standard that a court must apply. In the trailer dispute, the central issue was never whether unusual documents existed. The question was whether the loan agreement had been performed according to its terms. Once the court found that payments had stopped and no legally recognized payment had replaced them, the rest of the arguments could not change the contract itself. The second case shows a different kind of turning point. Earlier, the defendant focused on concepts like trusts, beneficiaries, and questions that never addressed the actual criminal charge. Those ideas may have seemed important, but they did not answer the legal issue before the court. As the case progressed, the discussion shifted away from those theories and toward practical decisions, legal representation, and finally resolving the charge. One pattern appears in both cases. Courts separate side disputes from the issue that is actually before them. A person may believe another wrong has occurred, but that belief does not automatically erase an existing legal obligation or defense. Judges repeatedly return to the narrow legal question because that is what determines the outcome. Sovereign citizen language often promises that changing labels, invoking the UCC, or questioning jurisdiction will change the legal relationship itself. These hearings demonstrate that courts instead look for recognized evidence, applicable law, and whether the required legal elements have been proven. Small strategic decisions made early in a case often shape everything that follows. By the time that becomes clear, the options available are usually much narrower than they were at the beginning.